Let's talk medical records. So much good information in this chapter, very applicable. And I think it's the shorter chapter. Yes, so like 14 pages ish. So hopefully it's straightforward. Of course, if it is not, please message me. Learning objectives are on page 218 and in this slide. Medical records means a communication, so it's definitely a planning tool for patient care. It's where everything is housed, the illness, symptoms, treatments, um, document, document communication progress notes. So no matter what the type of healthcare facility, whether it's primary care, urgent care, hospital-based, rehab hospital, it just doesn't matter. There has to be a progress note. And also every Ooh, I might have this wrong, but every shift, every 8 hours, no, every 12 hours, the patient has to be reassessed for their symptoms and diagnosis, etc., by not necessarily by a provider like a doctor, but by a nurse at minimum. And that may differ state to state, actually. But anyway, okay, so let's get into how medical records and health and law policy all relate. So, records must be complete, accurate, current, readily accessible, and organized in a system in some sort of fashion. I've been around long enough in the healthcare field. We used to document on paper, and it worked great, but there was always that human error of losing a chart, spilling a cup of coffee across a chart, and all that paper having it was wet, and then what do you do with it? You have to scan it to archive it anyway. So I am glad that we have electronic medical records as of today. So it's great. Even as a healthcare consumer, it's much more convenient for me to log on to a my chart than it is to go run to the hospital, ask them if I can have a copy of my medical record, then pay them, etc. Because, by the way, the medical records are property of the provider, whether it's a hospital, urgent care, doctor's office. And we do have rights as patients or healthcare consumers to ask for copies. We also have the right to say, my spouse or my sister or my mother or my uncle, you can give them information about me too. So I'm going to continue reading on page 219. Let me go back to the slide real quick. I want to make sure that I don't miss anything. So yes, the medical record provides a database for statistical reporting, continuing education, research, what we need to make sure the patient has everything they need. Ownership and release of records the ownership is the provider of the care. So again, you as a patient, you do not own your medical record. The person that you receive your care from owns that medical record. We do have a right to access. A failure to release a patient's record can lead to legal action. Oh, it will. Definitely will. You have to release a patient's information. Some institutions require payment, some do not. Third parties like insurance carriers, medical research educators, criminal investigations, absolutely. A lot of people are under the impression that well, it is. I was going to say that criminal investigation, health information is a right to privacy, and it is. So, for example, where that privacy impact comes, whether it's a drunk driver in the emergency room or someone who's been shot or, any type of healthcare evidence, there is a privacy while the patient is in the hospital, but criminal investigations will supersede and they can subpoena the medical records to find out what the blood alcohol content was. Was the person high on cocaine or meth or heroin? So there is some privacy, but there's limits. As long as the medical record is subpoenaed, we don't just hand over medical records to police officers or detectives. That's not the appropriate way. There's a chain of command, if you will. Okay. Legible, of course, medical records have to be legible, accurate, and timely written. So this is definitely improved with the invention or use of electronic medical record. Um, Legibility was a huge thing for many decades in healthcare, and it talks about that actually a little further in the chapter. So let me not get ahead of myself. Let me follow these slides. Privacy Act of 74. So this is when Congress, I think, enacted a safeguard for individual privacy from the misuse of federal records, and it gave individuals access to their records concerning themselves. So that's what's important to know about the Privacy Act of 74, which was recent. Like 74 was not that long ago. HIPAA. HIPAA is a huge thing that we talk about every time we go into a healthcare facility because every patient has to click that they receive the HIPAA information. And it's what it comes down to is privacy, confidentiality, and the security of patient information. You have to do all that. You have to keep people's information private, confidential, security of the information with the electronic medical record that we have now. What this means for staff is when I walk away from a computer, I badge out or I sign out. I do not leave my computer open for someone to come walk in behind me and look up somebody's information. Oh, here we go. Here's the key provisions for HIPAA. Documentation of treatment is talked about on page 221. Basically, in the court of law, in a court of law and health law and policy, if it is not documented, it was not done. And I mean down to giving a patient a drink, a blanket, Tylenol, of course, that's a medication. Simple things like patient's spouse entered the room, going to stay overnight. If seriously, in the eyes of the law in healthcare, if it's not documented, it was not done. And of course, we document the big stuff like dressing changes, wound treatments, medications, but no, literally everything is documented that we do, and you have to. Retention of records, this is very important. There are different regulations of how long how long healthcare facilities have to keep records. I say indefinitely, but that's not real. There's a statute of limitations, and I don't know what that is, to be honest. Electronic records, advantages. Oh gosh, so many advantages. Again, I am all for the electronic records that we use today. I was definitely not one of those nurses that was anti electronic records. I love them because everything is typed out. You can read it. The problem list is right there for you. The history and physical exams, the vital signs can be tracked. Where once upon a time when it was on paper, you have to flip through 50 pages to go see what their vital signs were 4 days ago, where now the vital signs all show up on one page on the computer. So it's definitely handy. Also, yes, order entries for medications, critical alerts can come via the computer, via an alert system. And if, as a nurse, I'm entering all this important information from my role, but someone who comes behind me, such as a physical therapist or a lab person, or maybe a PA is coming to see the patient that day instead of the doctor, they can literally just click a button and all the information they need is right there. So it improves the time to share the information, productivity, quality, and of course, excellent outcomes is what we're all about. Now, disadvantages, yes, there's a risk of loss of confidentiality. Again, if somebody leaves the medical record open or somebody hacks a system, that type of stuff. Unauthorized disclosure of information, increase in cybercrime, yes. It's actually been on television a couple of times where the medical shows have an episode about being hacked and losing control of the hospitals. Okay, high tech. Where was this in the book? Oh, I see it. The bottom of page 224, the left-hand side of that page. Read that definitely. Oh, then it also talks about data breaches. So that's good information to know. Medical record battleground when it comes to healthcare and policy and law. Definitely read that. Page 225 in the book. Communications between caregivers, failure to note an order change, all this you have huge legal implications for any of this. Medical identity theft, that is a real thing. Excuse me. I may have to mute. Hang on. Sorry, I coughed, but I put myself on mute. Um, there is a significant medical importance or legal importance of keeping good records. Okay. I'm going to try to make it through this. Medical identity theft is a real thing. As a healthcare consumer, it's totally our responsibility too to keep up with claims, make sure somebody has not stolen our identity. When somebody enters into a healthcare facility, Oh, sorry. It's also the registrar's responsibility to determine the identity of the person that is coming in before they're even seen. So there's a lot of legal issues with that. Okay. Hopefully that was the last time. All right, moving on. Page 226, bottom right, falsification of records. Oh my goodness. This is a huge no no. Intentionally, unintentionally, it does not matter. And yes, you can unintentionally falsify a document. Read this and just read it through the lens of a healthcare attorney or a healthcare judge. Some of the stuff that happens, even that little the not case study, but the example that's given, people versus Smithtown General Hospital, it happens. Tampering with records, erasures and write overs. You don't ever erase something, and you can never write over something or white it out. Like, white out is a huge no no in a healthcare facility. Now, of course, some of that's been taken away because of the electronic health record. You can't white it out anymore. But if you ever make a mistake in writing a healthcare record, in any type of healthcare record, you simply draw one line through it. You can put the word error and your initials, but you don't ever write over it, and you don't use whiteout. Leave it there, and just in a court hearing, mediation, arbitration, anything that we go through, it's better to see what the original line was and that somebody recognized that they made an error. You can even date and time when you realize that the error was made, but you just never try to erase it. That's a big no-no. Illegible handwriting, again, some of this is older, just because we don't do this. Well, I shouldn't say that. Med errors can still happen because doctors do have to provide paper prescriptions for certain drugs, so that you can still make med errors. But remember, the doctor writes it on paper, but there's a pharmacist somewhere filling it. So that pharmacist is also liable, because you have to stop and question, is this a normal dosage? Is it not enough? Is it too much? Like, it's not just a singular liability when it comes to that. And I don't know if I said this, but the illegible handwriting issue has diminished ever so slightly because of the electronic health record now. Confidentiality, privileged communication, yes, of course. Attorney-client privileges, Joint Commission reports privilege, they're very privileged. If we get complaints, if a healthcare facility receives either 3 or 5 complaints a year, Joint Commission will come back in, and we can be audited by DHHS and a couple of other places. Okay, so I have moved on to page 229 in the book. We're almost at the end of the chapter. Charting and helpful advice. Complete and pertinent entries, absolutely timely entries. I was never, and I do not recommend this to anybody, do not be that healthcare worker that charts at the end of the day. No, no, no. You chart between each patient, whether you are the registrar, welcoming people, whether you're the medical assistant taking the patient back to the room. Do not chart that you took the 10 a.m. appointment back at 4 p.m. in the afternoon. That's not when you should be doing your charting. You should chart with each patient. Trust me on this. This is just good practice to chart on time, legibly, clear, and meaningful entries. So oftentimes, healthcare professionals, if they go back to school for a higher degree or to extend their education, we typically struggle writing papers because charting is not like writing. It's very different. Charting makes us take from a very academic writing world to, you just include subjective information, just whatever, pertinent, subjective, matter of fact, patient stated, patient denies. So we lose some of our writing skills because of charting. And then, of course, I think as a society, we've lost some of our writing skills because of texting and emailing and other arenas. But definitely, charting is very different than writing papers. Avoid defensive or derogatory notes. Do not erase or use correction fluids like whiteout. Avoid criticism. Avoid complaints. I would not. I would still chart that a patient's complaining of room temperature or complaining of um, staff, and maybe just leave it very subjective like that. And then what I would put at the end of that note is see my, oh, what is it called? You can actually document. The thought lost me. At WakeMed we have a way to enter in patient complaints into the system, and I cannot think of what it's called, the platform. But anyway, that's what I would document. I guess I wouldn't document verbatim what the patient's necessarily complaining about, but I would definitely document that the patient has a complaint. They have a right for me to document that in the chart. So obviously I don't agree with that one, but that's okay. Do not tamper with the chart. That's a big no-no too. Secure records pending legal action, of course. Again, there is a time period that a facility should keep medical records, statute of limitations, and I don't know how that differs state to state, but definitely you have to secure the records. Patient care is a collaborative interdisciplinary team effort. Of course it is. It takes a village. Oh, and then the rest is review questions. So there you go. So yeah, please review Chapter 11. I think it's straightforward. If you do not, let me know, and I'm here to help.